Who had filed the MC?
MC has filed by the husband, my lordship,
Yes.
under section 12, not 13, my lordship, setting aside dissolve the marriage on the ground of medical ground.
Annulment. While the petitioner and his mother were traveling to Tumkur, respondent sent him a message containing hateful words against his mother. Petitioner showed the messages to her parents, but they were not willing to help. And instead, her father mentioned that the respondent has thyroid issues and requested the petitioner to get it treated. These are the messages I want.
Procedure before lordship was, if they had mentioned that pleadings about this document at the petitioner itself, what are the details, exchanges, or what are the contents, I would have been filed a different statement of objection to those documents by taking instruction from our client. Secondly,
These are all matrimonial matters. The technical aspect of in other matters you can't apply to the facts of in a matrimonial case. Yes.
the petition herein has challenged the order passed by the trial court by considering the application filed by the respondent herein, Order 7 Rule 14A, on the ground that there is no pleading at all either in the petition or in the evidence. It is well settled position of law when there is no absence of the pleading, no documents cannot be considered before the trial.
Yes. See.
And
Who had filed the MC?
MC has filed by the husband, my lordship,
Yes.
under section 12, not 13, my lordship, setting aside dissolve the marriage on the ground of medical ground.
Annulment.
What is the stage of the suit?
Further evidence.
They're done for further evidence.
Going on.
Further evidence.
It's not closed. I laid evidence. Immediately after leading evidence, I filed an application for production of additional documents under Order 7 Rule 14.
For what purpose you want to file this?
So messages between the husband and the wife were exchanged while they were living together. So to her state of mind.
Prove what? You must have stated so in the affidavit.
I've said in my petition itself.
Let's see.
Kindly see para 4 of the petition on page number.
No. Page number 30 is your affidavit.
Yes. Para 2, what I have said. By inadvertence, I have not produced a document mentioned in the accompanying application along with the petition, though they form part of material in support of allegation made in the petition. Not the allegation is there in the petition.
There should have been a specific contention at the now when you want to file this application
Yes.
at a stage, not along with the main application.
Yes.
You should say that these WhatsApp messages contain or a simple just for proving my case. It is essential.
But I've said that in paragraph number 3.
In support of my
The
evidence.
document is necessary to prove my case and for effectual
No, it's
adjudication.
a general statement.
What the message
What is there in this? What is your case? What are these documents?
that is there in para number 4 of the petition itself. In the petition, I've said
Because the application is not allowed, great hardship and injury will be.
It could have been better drafted. I concede, my lord. But kindly see para 4 of the petition. I've made a specific allegation that the messages are exchanged between the husband and the wife, which go to prove that everything is not normal in the relationship or with the
See that?
person.
Let's see.
Para 4, mother left Tumkur while she stayed with the petitioner's father at Bangalore due to the course. While the petitioner and his mother were traveling to Tumkur, respondent sent him a message containing hateful words against his mother. Petitioner showed the messages to her parents, but they were not willing to help. And instead, her father mentioned that the respondent has thyroid issues and requested the petitioner to get it treated. These are the messages I want to place on record. This fact was not known to the petitioner, clearly shows that the fact of her mental and other health issues had been hidden by her parents. But ultimately, my lord, the petitioner before your lordship will have to show what is the prejudice caused. My lord, ultimately, the burden is on me to prove every single document that I rely upon. What is the prejudice that is caused to the wife, my lord, by me bringing the documents on record?
WhatsApp exchange between the petitioner and respondent.
Yes.
WhatsApp exchange between the petitioner
And respondent
and
sister and brother.
respondent sister. Text messages exchange between the petitioner and respondent. Screenshot of the message exchange respondent via Instagram. Pen drive containing. Yes.
The burden is on me, my lord, ultimately to prove this.
Reason is that, my lordship, this documents are to be produced before lordship was, if they had mentioned that pleadings about this document at the petitioner itself, what are the details, exchanges, or what are the contents, I would have been filed a different statement of objection to those documents by taking instruction from our client. Second thing is that those exchanges are between, those exchanges are between the husband and wife, I would have been give consent for that. It is exchange between the sister of the wife and brother of the wife. This is totally not relevant to all those documents.
Sister of the wife, brother of the wife.
The document what they have produced before the documents is that.
That's what it is between the between the petitioner and respondent brother,
brother and sister of the
petitioner and respondent sister.
sisters. Those documents are not totally irrelevant to this case. Reason is that, my lordship, they have taken a contention on that ground that the petitioner, they started dissolution of the marriage on the ground of medical, they have suppressed the facts of, she might have some medical issues, all those things.
No, maybe all these WhatsApp conversations contain that.
This is why I'm
information.
making submission before this. All the conversations are prior to the filing of the petition, not subsequent to the filing of the petitions. When this material facts were within the knowledge of the petitioner, this respondent.
That is true. It's filed at a later stage. Because it's filed at a later stage, is it a ground for the court to brush it aside is the question.
I am not saying that there
No,
is a.
no, we can understand. Now, the MC is of the year 2022.
Yes, my lordship.
It is not that after a long time it has been done. When is this application filed? On
23rd of
23,
January
2024.
2024.
MC is filed when?
But MC is
That's right.
filed not on
Date?
28th of January 2022.
So,
My
no,
evidence,
even it will be easy for you also to demonstrate how, what is the conduct of the petitioner also.
evidence comments
They're all
on
admitted documents. The conversation, what is the prejudice?
My condition is that, reason is that, my lord,
No, what is the prejudice to you? Tell the court.
prejudice means this, my contention is that the contention taken by the husband before the trial court is that only they have stated the messages, all those things. But they have not stated anything about what are the things happened in between the petitioner and respondent. One thing. Second documents are to be produced before the trial court or prior to that,
No,
this one. And they have not assigned the proper reason.
that is there.
Why they have
Legal
not stated
assigned.
anything about
No,
the,
these are all matrimonial matters. The technical aspect of, in other matters, you can't apply to the facts of, in a matrimonial case.
they have not assigned.
No, with all this, no, if you deny that these are not the conversations between you and the husband, and the burden lies on him to prove that there was a
I
conversation.
can understand that what this lordship is saying, can understand. Only thing is that what was prevented for them to state all those facts prior to filing of the petition, because these messages are taken place prior to filing of the petition in the year 2021 itself. When those facts were within the knowledge of those
That's what
persons.
they're all called the technicalities. We'll not go into it because it's filed at a later stage. We'll impose some costs. Oh, yes,
I
we'll
can
take
place
that
that
judgment.
decisions, ma'am. That should come to that first decision,
Yes.
pair
this-
number 11.
That's what I said. Suit, property, permanent injunction.
There is not,
It's not arising out of a matrimonial proceedings. What we apply the parameters in a matrimonial in a property dispute are not one and the same.
my contention is that those facts, what they were,
That I understood. That I
that is the
understood.
reason, my lord.
Para number?
11, my lordship.
Para number?
11 of the first decisions, my lordship. It will start from sixth line from the bottom, my lordship.
Uh,
To start from AR 1987 SC 1242.
uh.
It is well settled that in the absence of pleadings, evidence, if any produced by the parties, cannot be considered. It is also equally settled that no party should be permitted to travel beyond his pleading, and all the necessary and material facts should be
When
pleaded by the
when
party
we
in
talk
support
about
of the case.
WhatsApp messages between the parties, not necessary that like a suit in respect of property, all those things need to
My
be stated.
submission is that
Only thing is their their application affidavit should have been more clear when they're filing it at a later stage. That's the only thing the court finds.
I will leave it to the lordship.
Yes.
Reason is that those facts are well within the knowledge of the party. Before filing
That's
the
what will
petition
impose some
itself.
cost for that. The,
And that all the conditions should be open for me to cross-examine.
it's always open, otherwise why will, it will be an
They
injustice
will
to
take a
the party.
condition that since they are failed before the High Court, they cannot raise objection, all those
but
things.
the order
I
says
know that
respondent
I
has
know that
opportunity to
because
cross
I got experience before that trial court.
Say that, we will observe that. Yes,
The petition herein has challenged the order passed by the trial court by considering the application filed by the respondent herein, Order 7 Rule 14A, on the ground that there is no pleading at all either in the petition or in the evidence. It is well settled position of law. When there is no absence of the pleading, no documents cannot be considered before the trial.
Yes, see.